The certified letter arrived on a Wednesday, and I knew before I'd even finished reading the first paragraph that the woman behind it had spent considerably more time drafting it than she'd spent learning anything true about bees. It came from the Wraithwood Hollow HOA board, signed by the board president, citing a newly adopted amendment to the community's governing documents, Section 9.2, which prohibited the keeping of livestock, fowl, or insect colonies for any purpose on any residential lot within the association. I had 3 established beehives in my backyard at the time, the result of 4 years of careful beekeeping that had started as a single hive and grown into a small, productive apiary that I'd built up with real intention, real expense, and real expertise that I'd spent those 4 years acquiring through state-certified beekeeping courses, mentorship from a regional beekeeping association, and the kind of hands-on trial and error that anyone who's kept bees seriously will tell you is the only way you actually learn. The amendment gave me 30 days to remove all 3 hives or face escalating fines beginning at $200 per week. I want to tell you, before anything else, exactly how this amendment came to exist, because the path from neighbor doesn't like my hobby to newly adopted HOA bylaw specifically targeting insect colonies is not a path that happens by accident, and understanding how deliberately it was constructed matters for understanding everything that came after, including the part where the state of my residence formally declared my backyard a protected agricultural operation, and the woman who'd engineered the ban found herself on the losing end of a lawsuit she'd been so certain she would win that she'd told at least 4 neighbors, according to what I learned much later, that it was basically a formality. My name is Desmond Cal. I'm 51, I'm a retired Navy logistics officer, and I live in Wraithwood Hollow, a planned residential community of about 210 homes, on a lot I bought specifically because its half-acre size and southern exposure made it well suited for the apiary I'd been wanting to start since I retired 3 years before the bee ban began. 28 years in Navy logistics teaches you a particular relationship with planning, sequencing, and contingency, and when I retired, I found myself restless in the specific way that people who have spent decades inside structured institutional life often are, looking for something that would give my days the kind of purposeful shape the Navy had always provided without me having to think about it. I started with a single hive in my first spring of retirement, mostly out of curiosity sparked by a documentary my late wife had insisted we watch together about colony collapse disorder, a film that had stayed with me longer than I expected and eventually turned into an actual hobby rather than just an interesting evening. I took the state's beginning beekeeper certification course that fall, a real program spread across 8 weekend sessions covering hive biology, disease management, swarm prevention, seasonal management cycles, and local regulatory requirements, taught by a state-certified instructor and a panel of working beekeepers who clearly loved what they did and wanted everyone in the room to understand it wasn't a casual undertaking. By the following spring, I'd added a second hive, having learned enough in my first season to feel confident about scaling slightly. By the spring after that, a third, the maximum I felt I could properly manage given my available time and the lot's actual forage capacity, since overcrowding hives beyond what the local nectar flow can support is one of the more common beginner mistakes the certification course had specifically warned against. I joined the Regional Beekeeping Association, started attending their monthly meetings, where I met beekeepers who'd been at it for 30 and 40 years and who became genuine mentors over those early seasons, and began selling small batches of honey at the county farmers market under a state-registered cottage food producer license, which I'd obtained specifically because I wanted to do the operation properly with all appropriate documentation. Even though the scale was modest enough that I could have probably gotten away without it. I want to be specific about the scale, because it matters enormously for understanding the absurdity of what eventually happened. 3 hives, on a half-acre lot, positioned at the back corner of my property, 40 feet from the nearest fence line, oriented so their flight paths went up and over rather than across neighboring yards, exactly as the state's recommended siting guidelines describe for residential apiaries to minimize any interaction with neighboring properties. I'd done everything by the book, the way I do most things, a habit 28 years of military logistics doesn't let you unlearn even in retirement. I'd registered the hives with the state apiary inspection program, which is mandatory for anyone keeping bees in my state regardless of scale, and which results in an annual inspection by a state apiary inspector checking for disease, pest issues, and general colony health. I'd passed every inspection with no issues across all 4 years. The woman who would eventually engineer the ban was named Carol Vance Prout, who lived 3 houses down from me on a lot that didn't border mine directly, but was close enough that, on certain afternoons when the wind was right, she claimed she could hear them. A claim I found difficult to credit given that honeybees in flight produce a sound roughly equivalent to background ambient noise from 40 feet away. Audible mainly if you're standing directly next to a hive entrance during peak foraging hours, which Carol, to my knowledge, never had occasion to do. Carol's relationship with my bees began, as far as I can reconstruct it, about 8 months before the ban amendment passed, when she filed her first complaint with the HOA citing concerns about insect proliferation and potential allergic reaction risk to vulnerable community members. This complaint was reviewed by our property manager at the time, a thoughtful man named Reginald Forsyth, who consulted the HOA's existing governing documents, found no provision prohibiting beekeeping, noted that my hives were registered with the state apiary program and had passed inspection, and dismissed the complaint as not constituting a documented violation. He sent me a courtesy copy of the dismissal, which I appreciated, along with a brief note saying he hoped the matter wouldn't recur. It recurred. Carol's second complaint, filed 6 weeks later, claimed that the bees had aggressively swarmed a child playing in a yard 2 houses away, an incident that, when Reginald investigated by speaking with the family in question, a couple named the Ferraros whose son had been the one allegedly swarmed, turned out to describe a single bee landing briefly on the boy's juice cup before flying away, an entirely unremarkable foraging behavior that any beekeeper could explain in about 10 seconds. Which Reginald, to his credit, did, in writing, in his dismissal of the complaint, including a brief, fairly charming explanation of honeybee foraging behavior that I suspect he'd researched specifically for the purpose of that dismissal letter. The third complaint, the fourth, the fifth, the sixth, each one followed a similar pattern, a vague or exaggerated incident reframed as a serious community safety concern, each one reviewed and dismissed by Reginald because none of them described an actual rule violation or a substantiated safety issue. By complaint number 7, Reginald had started attaching a standard note to his dismissals, citing the cumulative pattern of unsubstantiated complaints from the same source, language that I'd guess was meant as a quiet signal to the board that something other than genuine community concern was driving Carol's persistence. What I didn't know, and wouldn't learn until much later through documents that became relevant during the lawsuit, was that Carol had spent those 8 months doing something considerably more strategic than simply filing complaints, and hoping one would eventually stick. She had been recruiting. Carol Vance Prout, it turned out, had served on the HOA's social committee for the preceding 3 years, and had used that position to build relationships across a meaningful portion of the community, relationships she began leveraging sometime around complaint number 5 to build support for a more permanent solution than the complaint process was providing her. She organized what she described to other residents as an informal neighborhood safety discussion at her home, to which she invited approximately 15 households. Framing the conversation around general concerns about insect-related allergic reactions and liability exposure for the HOA as a whole, never mentioning my name specifically in the invitation, but according to 2 attendees who later described the meeting to me, a couple named the Castellanos who lived across the street from Carol and had attended mostly out of curiosity, making her position about a specific situation on Birchfield Lane extremely clear once the meeting was underway. Complete with printed handouts featuring stock photography of aggressive-looking bee swarms that bore no resemblance to anything an actual honeybee colony does under normal circumstances. I lived on Birchfield Lane. There was one beekeeping situation on Birchfield Lane. The Castellanos told me later that several people in the room had looked at each other with visible confusion, since most of them had never heard a single complaint about my bees, and several specifically mentioned they'd enjoyed seeing the increased pollination activity in their own gardens since I'd started keeping hives. From that meeting, Carol built a petition, which she circulated over the following month, requesting that the board consider amending the governing documents to explicitly prohibit livestock, fowl, and insect colony keeping on residential lots, framed in the petition language as a matter of community safety standardization rather than anything specific to me or my hives. She gathered, according to the petition copy that eventually became part of the case record, 41 signatures out of approximately 210 eligible households, which she presented to the board at the next quarterly meeting along with a prepared statement about liability exposure that I later learned she had drafted with input from her brother-in-law, a man named Carl Prout, who was, conveniently, a general practice attorney with no specific expertise in either apiculture or HOA governance, but who had apparently been willing to lend his credentials to a presentation designed to sound more authoritative than its substance actually supported, citing a single out-of-state case about a different kind of livestock that had essentially nothing to do with regulated, state-registered beekeeping. The board, faced with a petition bearing 41 signatures, representing under 20% of the community, and a presentation invoking liability concerns delivered with the borrowed authority of an attorney's name attached to it, voted 3-2 to adopt the amendment. I want to note the vote counts specifically because it tells you something important. This was not a unanimous community judgment against beekeeping. It was a narrow vote, achieved through 8 months of strategic organizing by one determined resident, against a hobby that had, by every objective measure available, caused zero documented harm to anyone in the 4 years I'd been practicing it. I received the certified letter the following week. I'll admit that my first reaction, reading that letter at my kitchen table, was something close to disbelief, the specific kind of disbelief that comes from being told you have 30 days to dismantle something you've spent 4 years and a meaningful amount of money and expertise building, based on a bylaw that didn't exist a month earlier, passed by a board that had spent 8 months dismissing the same complaints as baseless before suddenly reversing course. But disbelief gives way to action fairly quickly when you've spent 28 years in military logistics, because if there's one professional skill that career teaches you above all others, it's how to assess a problem methodically and build a response with the right resources applied in the right sequence. The first call I made was to my state's Department of Agriculture, specifically the Apiary Inspection Program Office I'd been registered with since my first hive, because I wanted to understand, before doing anything else, exactly what protections existed for registered beekeeping operations under state law, separate from whatever the HOA thought it could regulate. Woman who answered, a senior apiary program coordinator named Dr. Myral Tanaka, listened to my situation with the particular focused attention of someone who had clearly encountered versions of this conflict before. This comes up more than people realize, she told me. HOAs adopting blanket prohibitions on beekeeping without understanding that, depending on how the operation is structured and registered, state agricultural protections may preempt local governance restrictions. Can you tell me about your registration status, your inspection history, and whether you're operating under any state agricultural designations beyond the basic apiary registration? I told her about my cottage food producer license for the honey sales, my 4 years of clean apiary inspections, my certification coursework, and my membership in the Regional Beekeeping Association. She was quiet for a moment, the particular quiet of someone doing a mental cross-reference against a body of regulatory knowledge most people never have reason to develop. I want you to look into something, she said. Our state has a Right to Farm Act, which most people think of as protecting traditional farmland operations from nuisance lawsuits, by new residential development encroaching on existing agricultural use. But the statute's definition of agricultural operation is broader than people assume, and it explicitly includes apiculture, beekeeping, as a recognized agricultural activity, provided the operation meets certain registration and commercial activity thresholds. Based on what you're describing, your cottage food license for honey sales combined with your state apiary registration may qualify your operation for Right to Farm Act protection, which would mean local ordinances, and more importantly for your situation, private HOA governing document amendments cannot prohibit the operation if it predates the restriction and meets the statutory definition. I asked her what that meant in practical terms. It means, she said, that if your operation qualifies, the HOA's amendment may be legally unenforceable against you specifically, because state agricultural protection law would preempt the private governing document restriction. I'd recommend you formally apply for protected agricultural operation status through our office, which involves a site visit and a documentation review, and I'd recommend you do it immediately, because that designation, once granted, gives you something considerably stronger than an HOA dispute. It gives you a state legal protection that exists independent of whatever your board decides to do. I scheduled the site visit for the following week. What happened during that visit and what happened when Carol Vance Prout found out about it is where this story turns into something she had clearly never anticipated having to contend with. When we left off, I'd scheduled a site visit with the state's apiary program to apply for protected agricultural operation status under the Right to Farm Act, a designation that, if granted, would mean the HOA's new ban on insect colonies couldn't legally be enforced against my operation. Here's what happened during that visit, what happened when Carol Vance Prout found out, and how this entire situation ended with her facing a judgment she had told the neighborhood was basically a formality in the opposite direction. The site visit happened on a clear Tuesday morning, conducted by a field inspector named Otis Brandt, who worked under Dr. Tanaka's program and who spent close to 3 hours at my property, considerably longer than the standard annual inspection visit, because a protected status application required a more comprehensive review than a routine health check. He was a quiet, careful man in his 60s who'd clearly been doing this work long enough that nothing about a backyard apiary surprised him, and who moved through the hives with the unhurried competence of someone who'd long since stopped needing to perform expertise because the expertise simply showed in how he worked. He examined all 3 hives individually, lifting frames to assess brood pattern and population density, checking for signs of disease or pest pressure, and noting the general vigor of each colony in a small field notebook he carried specifically for this purpose. He reviewed my 4 years of inspection records against his own program's database to confirm consistency, cross-referencing dates and findings with a thoroughness that told me he took discrepancies seriously even when, in my case, there weren't any to find. He examined the siting and orientation of the hives against the state's recommended residential apiary guidelines. Walking the property line with a measuring wheel to confirm the 40-foot distance I'd always cited was accurate rather than approximate. He reviewed my cottage food producer license and sales records, asking specific questions about volume, frequency, and market presence that I answered from memory because I'd been keeping those numbers close enough to know them without checking. And he asked detailed questions about my operational history, my training, and my plans for the apiary going forward, questions that felt less like an inspection and more like a genuine conversation between 2 people who took the same hobby seriously, just at very different scales of professional involvement. He was thorough in a way that I genuinely appreciated, because I understood that the strength of whatever designation came out of this process depended entirely on the rigor of the review behind it. Toward the end of the visit, standing near Hive 2 with his clipboard, he said something that stayed with me. "I want to be honest with you, Mr. Cal. Most of the protected status applications I review involve operations that are scaling up specifically to qualify, sometimes adding hives or sales activity right before applying in a way that looks engineered for the designation. Your situation is the opposite. You've been operating exactly this way for 4 years before any dispute existed. That matters enormously for how clean this application is going to look. The formal designation came through 6 weeks later. State-issued Protected Agricultural Operations Certificate, specific to my apiary, citing the Right to Farm Act provisions, my registration history, my cottage food license, and Otis Brandt's site assessment, establishing formally and on state letterhead that my beekeeping operation predated any local restriction and qualified for statutory protection from nuisance ordinances and private governing document restrictions that would otherwise prohibit or substantially limit the operation. I sent a copy to the HOA's property manager, Reginald Forsyth, along with a formal letter from my attorney, a property and agricultural law specialist named Yolanda Reyes, who I'd retained shortly after receiving Dr. Tanaka's initial guidance, explaining that the Right to Farm Act protection preempted the Section 9.2 amendment as applied to my established operation, and requesting the HOA formally acknowledge that the 30-day removal demand and associated fines were unenforceable against me. Reginald forwarded the letter to the board and to the HOA's own attorney. I assumed, given the clarity of the state designation, that this would be the end of the matter, the same kind of quiet resolution I'd seen happen in other disputes once a clear legal fact entered the picture. It was not the end of the matter, because Carol Vance Prout did not accept being preempted gracefully. What Carol did next, which I learned about through the formal court filing that arrived at my house about 5 weeks after the HOA had acknowledged my protected status and formally rescinded the fine threat against me specifically, was file a private civil lawsuit in her own name, separate from the HOA entirely, seeking a court injunction to force the removal of my hives on private nuisance grounds, arguing that regardless of state agricultural protection status, the hives constituted an ongoing nuisance to her personal use and enjoyment of her property based on alleged noise, alleged insect proliferation, and alleged psychological distress arising from her stated fear of bee stings, a condition her filing described, somewhat dramatically, as apiphobia significantly impacting quality of life. I want to note something about the timing here, because it matters. The HOA itself, once presented with my state designation, had backed off entirely. The board, or at least the majority of it, understood that pursuing enforcement against a state-protected agricultural operation was a legal dead end that exposed the association to its own liability. Carol, apparently unwilling to accept that her 8 months of strategic organizing had produced an outcome that the state had just made permanently unenforceable, decided to pursue the matter personally, using her brother-in-law's general practice firm to file the case, presumably believing that a private nuisance claim, rather than an HOA enforcement action, might find a path around the Right to Farm Act protection that the HOA amendment hadn't. Yolanda was, when I called her about the new filing, more amused than alarmed. "This is actually a very clean case to defend," she told me. "The Right to Farm Act doesn't just preempt HOA governing documents. It specifically and explicitly bars private nuisance claims against protected agricultural operations, provided the operation is conducted using generally accepted agricultural practices and hasn't substantially changed in nature or intensity since it was established." We have 4 years of documentation showing exactly that. We have a state inspector's assessment confirming best practice siting and management. We have your inspection history. This is precisely the scenario the statute was written to prevent. A neighbor using a nuisance claim to force out an established agricultural operation that predates their objection. The lawsuit proceeded to a hearing about 4 months after Carol filed it, held in a county courtroom that, by the standards of dramatic legal proceedings, was an unremarkable mid-sized room, but which felt considerably more significant to me than its modest furnishings suggested, given that I was sitting there because a neighbor had decided my hobby was worth a private lawsuit after the HOA route had already failed her. Yolanda presented the full record methodically, the way I imagine any good attorney builds a case when the underlying facts are this clean. My 4 years of consistently passed apiary inspections, the Protected Agricultural Operations Certificate with its detailed findings, Otis Brandt's site assessment confirming best practice management at every measured point, the cottage food license and sales history establishing genuine commercial agricultural activity rather than a casual hobby dressed up to claim protection. And the right to farm, Act-specific statutory language barring nuisance actions against qualifying operations conducted using generally accepted agricultural practices. Carol's case, by contrast, struggled from the outset. Her claims of noise disturbance had no supporting evidence beyond her own testimony, which under cross-examination became considerably less confident once Yolanda asked her to describe, specifically, what she could hear and from what distance and at what time of day, questions Carol answered with increasing vagueness, at one point describing the sound as a kind of humming, sort of when the wind's right, language that the judge noted in his eventual written ruling lacked the specificity necessary to establish a substantiated noise nuisance. Her claim of insect proliferation was contradicted directly by Otis Brandt's expert testimony, delivered with the calm, technical authority of someone who inspects apiaries professionally, establishing that honeybee populations from a well-managed three-hive apiary do not meaningfully increase ambient insect presence beyond a tight radius of the hives themselves, a radius that, given the documented distance between my property and Carol's, did not reach her yard in any measurable way according to standard foraging pattern data. Her apophobia claim, while not something the court dismissed as illegitimate as a personal experience, was found legally insufficient to override statutory agricultural protection absent evidence of actual exposure or contact, of which there was none documented across the entire 4-year period. Yolanda had asked Carol directly, during cross-examination, whether she had ever been stung by one of my bees, or had any documented incident involving direct contact with them at all. Carol said no. Yolanda asked whether she had ever, in 4 years, actually visited my property to observe the hives directly rather than relying on second-hand description. Carol said she hadn't felt the need to. The judge's written ruling, which Yolanda read to me over the phone the day it was issued, her voice carrying the specific satisfaction of an attorney watching a clean case land exactly where it should, was about as clear a vindication as I think any beekeeper in my position could have hoped for. It found that my apiary qualified as a protected agricultural operation under the Right to Farm Act, that the operation had been conducted using generally accepted agricultural practices throughout its existence, that the HOA's Section 9.2 amendment was unenforceable against the operation as a matter of state law preemption, and that Carol Vance, Pruitt's private nuisance claim failed on every element required to overcome the statutory protection. The ruling dismissed her case with prejudice, meaning she could not refile the same claim again, and because Yolanda had requested it given the documented pattern of the 8-month complaint campaign and the strategic organizing behind the HOA amendment, awarded me a portion of my attorney's fees, which the judge found justified given what he described in the ruling as a sustained and deliberately organized effort to circumvent clear statutory protection through private litigation after administrative avenues had been foreclosed. That phrase, sustained and deliberately organized effort, appeared in an actual court document with Carol Vance Pruitt's name attached to it, a fact that I understand became fairly widely known throughout Wraithwood Hollow once the ruling was a matter of public record, because court rulings generally are, and because the Castellanos, among others, apparently felt no particular obligation to keep quiet about it. The HOA board, separately, used the ruling as the basis for a formal amendment reversal, repealing Section 9.2 entirely at the following quarterly meeting, this time by a unanimous vote, with the board president noting in the meeting minutes that the association had no interest in maintaining a governing document provision that state law had just definitively established as unenforceable, and that had already cost one resident a private lawsuit she'd lost with prejudice. Carol resigned from the HOA's social committee about 6 weeks after the ruling. I don't know the specific reasoning behind the resignation because she's never discussed it with me directly, and our interactions since the ruling have been limited to the kind of brief, civil nods that neighbors exchange when they're sharing a community but not a relationship. I've heard secondhand that several of the 41 original petition signatories felt misled once the full scope of Carol's organizing campaign and the eventual legal outcome became known. Having signed a petition framed around general safety concerns without understanding it was the opening move in a sustained personal campaign against one specific neighbor's established hobby. My 3 hives are still in the back corner of my half-acre lot, 40 feet from the fence line, exactly where they've always been. I added a 4th hive the spring after the ruling, partly because the apiary's productivity justified it, and partly, I'll admit, because there was a certain satisfaction in expanding an operation that a neighbor had spent 8 months trying to eliminate entirely. I sell honey at the farmer's market every season under my cottage food license, the same license that had helped establish my protected status in the first place. The Protected Agricultural Operations Certificate hangs framed in my garage, next to my beekeeping certification, and a photo from my last day in the Navy, 3 documents that, taken together, tell a fairly complete story about how I approach things I've decided are worth doing properly. Dr. Tanaka's office uses my case, I learned later, as a reference example when fielding similar inquiries from other beekeepers facing HOA restrictions, which feels like a fitting use for 4 years of careful, well-documented work that one determined neighbor tried very hard to undo, and that the state of my residence ultimately decided was worth protecting permanently. The bees, for what it's worth, have never once swarmed anyone's child's juice cup again. As far as I know, they never did the first time either. Thumbnail text, 10 words. She banned my beehives. The state declared them protected farming.